Welcome, everyone. My name is Andrew, and this evening is the final class of the July 2024 MBE Comprehensive Crash Course, and it's been an absolute pleasure to be here with everyone, and I'm very confident in how all of you are going to perform on Wednesday. So what we're going to do today may not be the most fun exercise, but it is going to be the most valuable. So what I've had Ali do is combine our cram guide into one comprehensive master cram guide. And I'll share this in the classroom because I already know that question was coming. And I'll go over it tooth and nail, and we'll all be smarter for it. So please try to keep the questions pointed because I want to get through the material, but I am always open to answering questions. Let's start with contracts. So a requirements contract does not need quantity terms. So if it's for all that you require, even though the UCC essential terms test usually dictates that there must be a quantity term, if it's a requirements contract, we don't need quantity terms. A contract that has consideration is validly formed and does not need to rely on performance or detrimental reliance to be enforceable. So once the contract has been formed, offer, acceptance, and consideration, nothing else is needed. Both parties are obligated to perform under the contract. After a party repudiates clearly, the other party cannot recover for expenses incurred after the repudiation because it was not reasonable to incur those expenses. For example, if a homeowner repudiates and then the contractor goes out and buys more materials specifically for the job, those damages are not recoverable, only the original expectation damages. So, if there's a repudiation and the other party knows that there's been a repudiation, then from that moment, it's unreasonable for them to continue incurring expenses. So let's look out for that fact pattern. Consequential damages we're always going to associate with the concept of foreseeability. If the facts state that one party had no reason to know that the other party would incur damages as a result of its breach, no consequential damages would be awarded. Takeaway from that, consequential damages must be foreseeable. Courts will try to enforce illusory contracts whenever possible. For example, if Tommy promises another man to pay him as soon as he is able, as soon as the man can prove that Tommy can pay, the contract is indeed foreseeable. So illusory is an empty promise. Like, I promise to tutor you when I feel like it. That's going to be unenforceable. You're never going to be able to prove when I feel like it. But if you say, Andrew, tutor me and I'll pay you when I have the money, well, that's something that can be proven. Bank accounts, right? Pull up the tax returns or whatever it may be. So even though it sounds illusory, the modern trend is to enforce contracts if at all possible. But the concept of illusory does mean an empty promise. So if A agrees to pay B $1,000 for a painting and it comes damaged, and A pays $400 more for repairs, and the painting ends up being worth $700, the total damages are $700. So this is a fact pattern that we should all be familiar with, where it's supposed to be $1,000 painting. You get it and it's damaged, right? And it's only worth, let's say it's only worth 400 when you get it, and then you end up doing more repairs on it. You're going to get the expectation damages. So like, what did you pay? And then what's the difference between what you expected? So in this situation, you paid $400 more for repairs. So it turns out you paid $1,000 for it, then you paid $400 more for repairs. You've actually paid $1,400, and in total, the thing's worth $700. So $1,400 minus $700 is going to equal the $700, right? 1,000 plus 400 minus the 700 equals the 700. The 1,000 you paid for it, the $400 you paid additionally, and then what's the difference in what it's actually worth? It's worth 700. You paid 1,400, so you're entitled to $700 in damages. An exception, this is a good one. An exception to the pre-existing duty rule is when the duty is owed to a third party. For example, an investigator who already has a duty to collect a painting from his employer may also collect privately from an individual who wants the painting recovered. So that fact pattern is investigator, he's looking to solve a mystery, and then the person who is interested in the mystery, right? It's their piece of art. They say, hey, if you find the art, I'll give you $1,000. That private investigator can get paid via his contract, and he can get paid via the agreement with a third party, because even though there's a pre-existing duty, that's one of the exceptions. Another exception, that's actually where I thought this point was going, is the agreement to pay off a prior existing debt. That's another common exception to the pre-existing duty rule. So an employee who's let go, the employer breached, has a duty to mitigate by taking any reasonably comparable job. So a day laborer is not comparable to a brick mason. If you were supposed to get a job as a brick mason and then they offered you a job as a day laborer, you're not obligated to take that. But if another job in the community was available as a brick mason and it paid $10,000 less, you would be obligated to either take that or not take that, but you could only collect the difference in what that job would pay and what the original job was supposed to pay. So also, if an employee takes any job, even if it's not comparable, the employee cannot double recover, only recover difference in salary. So Susie is supposed to be hired as a teacher. The principal rescinds the offer, and it was a $50,000 contract. And then Susie gets a job as a secretary for $50,000. She will have no damages, because even though she didn't have to take the job as a secretary, she took it and was getting paid $50,000. Now, if she chose not to take the job as a secretary, then her damages would be $50,000. And if there was a comparable job as a teacher for $40,000, she could either take it or not take it, but the damages available would only be $10,000, the difference. So speaking of Susie, if Susie sells her business and a condition is that she must stay on for 2 years, a breach of her employment contract will not affect the sale of the company. So like, if there's an agreement to sell the company and she has to stay on for 2 years, and then they tell her, hey, Susie, we're not going to keep you for 2 years, that's not going to invalidate the entire sale of the company. It would just, give rise to damages for the breach of employment contract. So assignees may stand in the shoes of the original parties and assert any claim that the original contract may have asserted, including claims for recoupment. So recoupment means that you're going to recover from a debt. Like if A owes B money and then C owes A money, B can recoup that money from C, because A owed B money, C owes A money, and a claim for recoupment, potentially B could get the money from C. So that could also be an assignee. We just said recoupment is recovery or collection of money that was previously unduly paid out. So if a party is named in a contract to receive payment, they're an intended third-party beneficiary. Let's look out for intended beneficiaries. An exception to the parole evidence rule is to clarify ambiguous terms. For example, if a party is to be held individually liable as a representative or not. That's the contract where like Mary signs it as president, and it's not clear if as president means like in her individual capacity, or if it means like as a joint and several liable party on behalf of the company. So remember, exceptions to the parole evidence rule: to show a condition to contract, a defect in formation, to clarify ambiguous terms, to show custom or trade usage, or to show an additional term to the contract, not a conflicting term. Delivery of non-conforming goods as a response to a prompt shipment order is an acceptance plus breach. Unless it comes with a notice of accommodation, then it's a counteroffer. Requesting a modification is not an anticipatory repudiation. It must be clear and unequivocal. So saying I'll try to do it is not an anticipatory repudiation. If you hire me to tutor you and I say, hey, I'm not feeling well, I'll try to tutor you, but I'm not sure if I'll be able to do it. That's not clear and unequivocal. A request for further assurances only necessitates a response if there are reasonable grounds for insecurity. There's no breach if you do not respond to a request that was sent without reasonable grounds for insecurity. So if you were like, you saw me out, people tend to do this. They follow me on social media and they see maybe I was like at regatta at 1 in the morning and I'm supposed to teach my class at 11, and then you guys send me all these letters like I'm demanding security that you'll be there at 11. Trust me, as my students Shelby and Daniela, who've worked with me since the LSAT, I've never missed a session. I'm very reliable. That wouldn't be grounds for insecurity. You have to have reasonable grounds for insecurity to request further assurances. Motives are irrelevant to contract acceptance. So a trained runner is allowed to accept a running challenge and complete even if she was already training on her own. So I did this for my company. I said, anyone who could beat me in the 5K that's on my team, I'll give an award to. And then they were like, this one kid who works for me, he's like a math tutor, is like on the UM track team. And I thought about this question and I was like, yeah, well, he doesn't count, but he would have counted. So in order for writing to conform to the statute of frauds, it does not need to be made contemporaneously with the agreement. So, me and Tommy or Tommy and I can come to an agreement and then we put it in writing later. That's fine, especially the confirmatory memo rule. But just in general, there can be a later writing that satisfies the conditions of the statute of frauds. There are some promises that lack consideration, like gifts, but are still enforceable under theory of reliance, which is promissory estoppel. A promise to make a gift in the future is not enforceable unless injustice can be avoided by such enforcement. This question, I remember, A looks like such a tasty answer. It's like the promise is not enforceable. There's no consideration. It's a gift. But then D is actually the correct answer because it's like, oh, well, if injustice can be avoided only by such enforcement, then they would enforce the gift. So be careful to always read all the answer choices. Under the UCC, goods are identified under the contract when the seller places a label on them. For example, when the seller places a label on the kayaks, the goods have been identified. The enforcement of a debtor's promise is a long-established exception to the pre-existing duty rule, as I was talking about earlier. For example, if a debtor owes a lender and the payment is barred by the statute of frauds, but the lender agrees to pay a smaller amount, this agreement is enforceable and does not lack consideration. So a long-established exception to the pre-existing duty rule is the debtor's promise to pay back earlier debt. Under the UCC, a buyer's duty to pay is conditioned upon tendered by the seller. So too, little Shakespearean language, if a contract is silent as to the place of delivery and time of payment, Gabby, this is a question we did together. The seller has no duty to deliver the goods at his or her place of business unless the buyer makes payment. So remember, if there's a contract and it's between two parties and it's silent as to where pickup will be, where is pickup? At the seller's place of business. Think about if you order, a TV from Best Buy and it doesn't say that Best Buy is going to deliver it, then you would have to go pick it up. And they have no duty to tender it to you until you show them the money. An offeror is the master of the offer and can expressly create conditions that prevail over, let's say, the mailbox rule, for example. So if it says the acceptance must be received by this date, that would prevail over the mailbox rule because the offeror is the master of the offer. The assignee stands in the shoes of the assignor. Repetitive. We like repetition. At common law, modifications are enforceable if both parties provide consideration. Under the UCC between merchants, there must only be good faith. Now, remember, there is the modern trend at common law where if the modification is to remedy an circumstance that was unforeseeable by both parties at the time of the agreement and it's in good faith, we will allow for that modification without consideration. Goods over $500 must be in writing. Partial performance is not satisfied if goods are delivered but not accepted. If accepted, performance would provide exception to the statute of frauds. Right, so just because you have an agreement for gold, let's imagine, and it's supposed to be in writing, but it's not, and you deliver the gold, that's not partial performance unless they accept the delivery. Most people actually get that question wrong. Courts will not enforce contracts of adhesion. And what's a contract of adhesion? Essentially, contracts created under duress or threat where there's no meaningful alternative or choice. So essentially, procedural unconscionability. I don't like the double use of the word essentially there. The word essentially brings me back to when I was in financial sales. Is the only frolic I'm going to take today. Not even a frolic, it's going to be a detour. But when I was in financial sales industry, I got my Series 766 and all that. They used to say that we were not allowed to use the word basically because basically implied that our products were basic. So we were supposed to use the word essentially. So now whenever I hear that word essentially or basically, I always think about that. I learned a lot of things about what you're allowed to say and not say when you're selling the same products that everyone else has. Now that I sell my own services and I feel really confident in their superiority, I don't have to use these sales tactics, but they were good to learn. I also served tables. I was a bartender. I know how to sell things, but now I just give you guys the goods. So let's get back to the goods. Undue influences focus on the relationship between the parties, right? So duress would be a threat, whereas undue influence would be a relationship, a special relationship between the parties. It can be tough. There's like one question where it's like a mechanic and a guy, and they say it's duress, but it's really procedural unconscionability. Just know it's not going to be undue influence unless it's a special relationship between the parties. Undue influence, really think of granny and the caretaker. An assignee can validly seek recoupment against an obligor for claims arising from the same contract. A hospital patient who gets sick is likely an incidental beneficiary of a contract between a janitor and the hospital. Under the firm offer rule, if there's an options contract, an offer that remains open between merchants, there's no need for consideration. And if the time for which the offer is to remain open is not stated, it will be 3 months, after which it becomes revocable. If the 3 months pass, but the offer is not revoked the offer, then the offeree may still accept the offer. Meaning after 90 days, it becomes revocable, but it's not automatically revoked. It still has to be revoked, but it's not irrevocable anymore. The doctrine of prevention is when authorities didn't convict the man, even though they had the info, they still had to pay the reward. So if they say, hey, we'll pay money for any info that leads to this guy's arrest, you give them the info, they could have used it to arrest him, but then he enters like a snitch deal. Well, that's the doctrine of prevention. They still have to pay you out because their behavior prevented the requirements of the contract from occurring. Course of dealing evidence is admissible as acceptance of parole evidence. Condition of contract is also acceptance of parole evidence. An assignee can only assign the rights of the assignor, right? You can't assign any more than that. When two parties have a contract, A and B assigns the duties or rights to C, then A becomes an intended beneficiary of the contract between B and C. Leaving out a term to be filled in later does not make a contract invalid under the UCC. When a confirmatory memo has the necessary terms, those terms will govern the contract so long as the confirmatory memo is not disputed within a reasonable time. A rejection revests title of goods to the seller. So if you reject the painting and then sell it, you are liable for the market price, not the contract price, and not for conversion. If there's a condition and it's implicitly waived, it cannot be raised as an offense. So if you have a condition not to drink, but acknowledge it, and then you're cool with it, then you waive it. Like if you say, hey, Tommy, I'll only do this work with you if you don't drink, and then you take tequila shots at the bar with him and say, here's to the contract, you've implicitly waived it. Under the UCC, an acceptance with a material additional term, the contract is valid, but the additional term is knocked out. Limitation on liability is a material term, right? An arbitration clause, it's up to the courts to decide whether it's material or immaterial. Something like, a few extra days or a little place of delivery or something like that is immaterial. Under the pre-existing duty rule, it does not apply if the duty is owed to a third person, right? We talked about that earlier with the investigator one. If there's a contract to deliver goods to a location and neither party shows up, the obligations of both parties are discharged under the contract. Under the UCC, an oral modification is valid if done in good faith. A construction contract, if there's a bid and there's reliance, this creates an options contract, and the bid cannot be revoked for a reasonable time. A repudiation can be retracted if the other person has not reasonably acted upon that repudiation to mitigate elsewhere. So if I'm going to sell you corn, and then I'm like, hey, sorry, I can't sell you the corn. And then a day passes, and I'm like, oh, wait, I can sell you the corn. I call you back, and I'm like, yo, I could sell you the corn. Is that retraction valid? It depends. In the meantime, have you already made efforts and secured a contract to get the corn from somewhere else, and now you paid him the money or something? Then maybe it'd be too late. But it sounds like a day later, I would be able to retract it. That was pretty incredible. We went through contracts. How's everyone feel about contracts? Ready to rock it? Ali's gonna be amazed when Ali sees this video.
Awesome. Thank you, Andrew.
Are oral modifications okay under common law? Yes, so long as they're supported by consideration, or like we said, so long as they are to remedy a situation that was not expected by either party when the contract was entered into and was done in good faith. But it's not really about the oral nature of it when it comes to the modification. So Rob's saying it's a deal. Is that a contract joke, Rob? Big Rob? It's a deal. We have offer, acceptance, consideration. All right, contract. In consideration, Rob, of you passing this test, I'm gonna prematurely buy you a drink at American Social in Tampa when the testing is done. But if you don't pass, no, I'm just kidding. It's all good. I know you're all taking it. Are you feeling better, Rob? I know you came down with the Corona 24. All right. Well, let's see. Let's see what if Rob's feeling better. Yeah, you're feeling better. Still no voice. Well, good. The good thing is the test is written, so you don't need a voice. And we know in evidence you can become familiar with someone's voice for the purposes of trial, but you cannot become familiar with someone's handwriting. If you are contagious at the bar, I encourage you to wear a mask. All right, let's talk about torts. I love torts, my favorite subject. Did you know I got the Cowie Award in torts? No, people make fun of me because I always say that, but you would say it too. All right, torts. Battery is intentional tort, and it's not relevant whether or not the conduct was reasonable, right? Battery is intentional tort. We're looking at the intent element, not the reasonableness element. The learned intermediary rule applies to doctors, for example, but does not apply for over-the-counter medications. Therefore, the defense that the over-the-counter medicine should be subject to the learned intermediary rule is a weak defense, right? Learned intermediary rule is like if the doctor, gives you some prescription and the doctor should have known about it and should have told you about it, but didn't. But over-the-counter medicine, it's not the doctor's fault. You should have read the warning label, most likely. Again, fact pattern specific. So there is no private nuisance claim when someone is unusually sensitive. For example, they are nocturnal and kids are loud during the day. Right? It has to be, they test that a lot, that there's no private nuisance claim if there's an unusual sensitivity. A store owner will not be liable for negligence. This is what I wanted Brooke to teach, but she did a pretty good job. Or at least has a strong argument against negligence. If an 8-year-old supervised kid who has shown no risk pushes a cart into another customer. And if anyone's watching this recording, Brooke is a 5-year-old child that I left in charge of teaching class at the beginning. And this is what I wanted her to teach, that, a store owner will not be liable for negligence, or at least has a strong argument against negligence if an 8-year-old supervised kid who has shown no risk pushes a cart into another customer, right? They had no duty. Having no duty is usually the first argument to not being liable. If someone gets sick, the person must prove that the restaurant caused the illness. It will not merely be inferred. So you can't just say, oh, everyone in the restaurant, you got sick. Like, you got to prove that, you got sick from something in the food. If a kid is driving a motorcycle, he will be held to an adult-like standard of care. A design defect is a design defect occurs if a product is unreasonably dangerous, especially if there is evidence of an alternative safer design, right? The risk utility test. If a lady pushes a man who has repossessed his car, the court should not grant summary judgment saying there's no battery because she may have used intentional force that was not reasonably privileged. Sounds like a Miami situation. I saw just recently, I've been working all day, but when I looked at my phone, there was like a dead body in the water in Miami. Just time stamping the day. Tortious interference, intentional interference with a business relationship, must be interference with a contract between two other parties, not your own contract. That's that airline question. So hopefully that makes sense to everyone, that tortious interference needs to be interference with contract between two other parties. Merely broadcasting news coverage is not IID because there's no outrageous behavior. There's no actual malice. They like to test that a lot. Like, the news doesn't really get in trouble for showing the news. There could be no vicarious liability to justify battery on behalf of a man for an airline if the man is merely a passenger. So it wouldn't be battery, but maybe it could be like negligence or some supervision claim. It wouldn't be strict liability, but there could be liability if they like failed to remove them, but it wouldn't be battery. Using a person's likeness for commercial purposes is appropriation, which is a privacy tort. It could also be misappropriation if they misuse it. A farmer whose livestock wanders into a highway and causes injury is likely liable for negligence, possibly under res ipsa loquitur. Like how else would the, cow have gotten into the street? A mall has a non-delegable duty to maintain a safe premises. A hotel, an inn, certain places have non-delegable duties. A dentist is a user of a needle, not a supplier. Therefore, if it breaks during surgery, the customer cannot sue the dentist for strict liability, products liability. You would have to sue the producer or manufacturer of the needle. The dentist would probably be the one who sues them. A dentist is not liable for malpractice if he exercised due care. Children doing adult-like activities will be held to the adult standard of care, like driving the motorcycle or riding the boat, as Meg likes to say. If a girl is sneaking into your garage, you cannot punch her in the face because that is excessive force. So I have to stop and talk about this one. So I had Ali, consolidate all these cram guides for me. And her first complaint was that it was too long, so it's not really a cram guide anymore. And my answer was, this is the MBE, not the exam to become a police officer, which I immediately felt bad about because I have a lot of respect for police officers, but I'm just a funny guy. And then, to be fair, it's not that hard of a test comparatively. It's a hard test to become a police officer, but it's not the bar exam. So this is a more comprehensive cram guide. And then my other point was, Ali said, does this question really need to go on the cram guide? Like, isn't that super obvious? And I said to her, you would be surprised how many people get this question wrong. This is the question where people think that it's valid defense of property. The girl is like sneaking into your garage, so you go punch her in the face, that's cool. And it's funny because to Ali, when she was creating this cram guide, this seems so obvious, but just kind of does show you, what we call analysis paralysis, where sometimes when you're so deep in doing questions, you get some obvious ones wrong. And then when you're someone who Ali's going to University of Chicago School of Law, she's just taking the LSAT. She hasn't even studied the law yet, but this was pretty obvious to her that if a girl's sneaking into your garage, you can't punch her in the face because that's excessive force. All right. So for retailer, manufacturer, supplier, producer, wholesaler, let's just make it more comprehensive. Sells a product without a safety device, and the evidence shows that it was foreseeable that injury would occur, they could be held liable under strict liability theory. If you suffer a heart attack and it's totally unexpected and foreseeable, then you're not liable because you not breach a duty of any duty of care. So this is the negligence per se one. There's a statute that says if you go across the median, you're liable. Tommy has a heart attack and goes across the median. Is he liable? The answer is no, because he had a heart attack. He didn't breach any duty of care. You do not owe any significant duties to an unknown trespasser. So for example, if you're shooting on your property, your neighbor trespasses onto your land and gets accidentally shot, you're not liable, especially if the neighbor knew you shot guns on the property. If a pilot makes an emergency landing, he's privileged to land, and the homeowner cannot send the dogs to attack. That's battery. Defense of necessity defeats defense of property in this situation. I brought my dogs to the boot camp. Lauren said she was going to be so scared of Rosie, and then came to realize she is not scary. The danger of falling off a ladder is obvious, and there's no duty to warn. Abnormally dangerous activities are non-delegable, so a general contractor will be liable for a subcontractor. One such abnormally dangerous activity is blasting. Mishandling of a corpse leads to an actionable claim by a relative for NIED, but is not strict liability tort. It's just that mishandling of a corpse is especially likely to lead to distress. For example, mislabeling of a corpse or failing to seal a body at a mausoleum. So they're pretty much going to be liable. You can assume damages, but it's not going to be strict liability. The proper remedy for conversion is the complete price of the chattel before the damage, not the actual damage to the saw. But it's not going to be the original price when you bought it. It's going to be the price before it was damaged. So if you bought the saw, it was worth 1,000, and then it rusted a little bit, now it's worth 500, and then they damage it to the point where it's worth 200. they're not going to be liable for the 300 because they probably converted it. They're going to be liable for the 500 that was worth before the conversion occurred. Common carriers such as airlines have an affirmative duty to protect passengers from other passengers, although it does not arise to strict liability. That's what I was saying earlier. If a person is injured by malfunctioning hospital door, the jury may find the hospital liable under res ipsa loquitur. How else would the door have malfunctioned if it wasn't for negligence? If a dealership hires a reputable EMS firm that has EMTs and one of the EMTs causes injury, the dealership is neither directly or vicariously liable, right? They could be liable for negligent hiring if they hired the wrong company or something like that, but the EMTs would be the ones liable in this situation. A great defense to battery is that the defendant did not know he or she was striking a person, because then they would not have the requisite intent. This one's tested a lot. To claim self-defense for battery, the defense must have been reasonable under the circumstance, objectionably, not subjectively. So Johnny attacks Tommy, Tommy takes out his gun and blasts him. Is that okay? Well, if a reasonable person in Tommy's shoes would have felt that they were under, threat of physical violence with a deadly weapon, then yes, it would be appropriate to pull out the gun and blast them. But if only Tommy thought that, because Tommy was like wild and he played a lot of Grand Theft Auto, like that wouldn't be a good defense if not everyone else would have thought that, right? Do we understand the difference between objectionable and subjective? If Tommy subjectively thought that defense was necessary, that's not the standard. It's whether objectively a reasonable person in Tommy's shoes would have thought that defense was necessary, that it would indeed be necessary. I mean, that it would indeed be proper as a defense. So if a drunk man, and no one who sees me at the after party will be a drunk man, you will all be reasonably buzzed, punches someone on the plane, the airline cannot be held vicariously liable for battery because there's no special relationship like a master servant. There's an absolute privilege of consent in libel cases. So, if you are at an interview and they ask you about why you got fired at the job, and then, they consent to asking you and you tell them, then that would not be liable. You do not need to prove damages to prove a case of trespass, only intent. So trespass is just the act of invading someone's property. Whether or not there's damages is a different question. There's no duty to unknown trespassers. So even if the tree is decaying, even if you shoot them in the head, if they're unknown trespassers, that's not your fault. The only duty you have is not to intentionally cause harm to people who would invade. So if you're responsible for an electric shock, then you being responsible will be the reason why you would be liable to an unknown trespasser if you're just out here shocking anyone who walks on your property. Any Jehovah Witness, you're sending them right to heaven. You'd be liable for wrongful death, most likely, and maybe even murder. You do not need, if known trespasser, you have a duty to make safe unreasonably dangerous activities, right? So if they're known, then you do have a little bit of a duty. If they're unknown, you really have very little duty. Licensed invitees have the heightened duty, and invitees have the highest duty to make reasonable inspections or sweeps. Look for the banana question. If the banana falls and it's pruned, that means, is that the word, pruned?
No. Blemished.
Like bruised?
Yeah, blemished, right? What does pruned mean?
Pruned means like you trimmed it, like you
removed
something.
Prune the leaves, yeah, like trimmed it. Okay, yeah, not pruned. Thank you. Blemish. So if it fell and it's blemished, that means it's probably been there for a while and they had a duty to sweep it. The ice, if it falls and it melts, that means it's probably been there for a while and they had a duty to sweep it. If the ice is still frozen or the banana has no blemishes, then that's probably an indication that it just fell and they didn't have a duty because they only have a duty to make reasonable sweeps. Very strange test, this MBE is. Shopkeeper's privilege allows reasonable detention to see if there's been theft. Summary judgment should be denied if there are triable issues for the jury. Was the guy negligent or not? So, when they ask for summary judgment, if you're like, this is best for a jury to decide, try to pick that answer. If a driver breaks a plaintiff's leg and the plaintiff later slips on a banana and while he's in crutches and breaks his arm, it's likely foreseeable and the driver is liable for injuries to the leg and the arm. Be wary to say it was superseding or intervening because it's pretty much, if you give a mouse a cookie, then he's going to ask for a glass of milk. Like one thing is pretty foreseeable to lead to the other. It's more difficult than you would imagine to break the chain of foreseeability on the torts questions on the MBE. So conversion damages are for the full value at the time of conversion. Caretaker institutions have an affirmative duty to protect their patients, for instance, a mental patient from sexual abuse. If Granny forgets to lock up the gun, she could be liable for little Tommy shooting it. If someone with no reason to know of conditions, no foreseeability, suffers a heart attack and causes the accident, this is what I talked about earlier, even if there's a per se duty via statute, there's no evidence of a breach of any duty because he would not have known he would suffer the heart attack. If you're trespassing and a hot air balloon lands on your head, you have no claim of action because they have affirmative defense that you're trespassing. The learned intermediary doctrine shields manufacturers from liability if they provide adequate warning to physicians for prescription drugs. No physical harm is necessary for the negligent handling of a relative's corpse because damages are presumed. Deadly force as a defense to battery is only available if the use of that deadly force was actual and reasonable under the circumstances. It is foreseeable in prox liability that a lighter will be used for arson, right? It's foreseeable, and it could also be foreseeable misuse. Like it could be foreseeable misuse that you'll use a lighter for arson, right? Private nuisance must be substantial and unreasonable in order to prevail, not something that's just like, Rosie barking at the squirrels. Intentional misrepresentation must be actual reliance and pecuniary damages. People get that one wrong a lot. Misrepresentation, there needs to be damages. So if you, represent something and you are, it's a misrepresentation and then you sell it to them and then they're able to resell it for that exact price, they didn't suffer any damages and they will have no claim. All right, cool. Contracts and torts. Those are the subjects I do first. I tend to tell people they're the easiest, but I've learned in the past that sometimes some of my students, for my expectations, underperform a little bit. And I think it's the nature of the subjects you do first, you tend to let slip away. So be careful about that and maybe brush up on some of these torts and contracts and other subjects that you may have done earlier over the next few days. All right, let's talk about the Constitution. So government-related restrictions on development constitute a taking unless rationally related to alleviate the harms caused by the construction. And if a taking must provide just compensation, for example, and if it's a taking, they must provide just compensation. For example, a government condition that construction must include an open to the public pool in order to alleviate an unrelated traffic condition in the town constituted takings and require just compensation, right? That wouldn't be a fair exaction because it's not rationally related. So the Tigard holding, when a government authority attaches a condition to a building permit, the burden on the property owner must be roughly proportionate. There must be a close logical nexus to the benefit for the government. So if it's again with the exaction, if they say, Andrew, you're building a school, but you also have to build a karate gym, because this town has an obesity problem, it's kind of like, what? Like, I'm not responsible for this town's obesity problem. I'm just out here trying to teach math. Like, why do I have to build a karate gym? It would probably be not proportionate. Under Article 3, federal courts have federal question jurisdiction over cases that arise under a treaty, for sure. Adult entertainment establishments such as strip clubs may be validly subject to time, place, and manner restrictions, content neutral, and there may be designated zoning for them. So when I was looking for my little hotel Airbnb, I almost got a place in Ybor City, which is a great example of this. In Tampa, there's one little neighborhood called Ybor City that has all the strip clubs. They're validly regulated by zoning ordinance via time, place, and manner regulations to that part of the city. But honestly, I want to focus during these. No, I'm just kidding. I got a better place somewhere else off the map. No location sharing. Congress cannot regulate non-commercial activity. For example, if there is a weed that grows and is fun to play with, I think that is a joke. It means like to ingest probably, but there's no commercial market because it's so abundant. Congress cannot regulate the weed. Congress, under the Commerce Clause, can regulate the channels, instrumentalities, and economic activities that in aggregate have a substantial effect on interstate commerce. Congress can delegate authority to executive agencies so long as they provide intelligible standards criteria. For example, guidelines for an essay winning contest to combat drugs would be acceptable. Article 3 affixes the U.S. Supreme Court jurisdiction between state suits involving ambassadors or important foreign officials. So Congress cannot amend original jurisdiction, but they can amend, modify, eliminate, or change the appellate jurisdiction. Definitely look for that answer. They can not amend original jurisdiction, but they can amend, modify, eliminate, change appellate jurisdiction. A state bar cannot deny admission to someone because of prior membership in a subversive group, but they can deny someone based on current membership if their intent on being in the group is to further its illegal purposes. Voting, running for office, serving on a jury, aliens are as a class are subject to rational basis, not strict scrutiny, because it's integral to the functions of the government. So typically, alienage is subject to strict scrutiny, but if it's related to the integral functions of government, such as being on a jury or running for office or voting, then it can be subject to rational basis. Honestly, the only reason I haven't run for president of the United States as an independent candidate is because I'm not 35 yet. But fortunately, 2028, my time is coming. And the reason they're able to put that restriction on candidacy of being 35 is because it's essential to the functions of government. The Commerce Clause is a broad power that allows Congress to regulate the economic related activities, channels, and instrumentalities. For example, the labeling of foods and drugs, right? Broad powers under the Commerce Clause. Consider Commerce Clause as a potential answer when it's listed. Don't just jump on it, but like be like, is this economic activities? Now, if it's Congress forcing a state to enact legislation, it might implicate commandeering clause in the 10th Amendment. The state is treated as a person for the sake of federal law and must comply with all regulations. I like that statement. In order to challenge a constitutional right, even if the right would be subject to strict scrutiny, the challenger must first establish that a constitutionally protected right exists, such as a due process right as a secretary. Under the Establishment Clause, the government cannot support or establish a religion or give certain religions preferential treatment. The freedom of association is limited if the person joins the group with the intent to advance the group's illegal activities. If a person is seeking an injunction to enjoin a party from building a bridge, but before the case is heard, the bridge gets built, it is moot. When I see that answer, it's moot. That's a great example of what I was saying earlier. Look at the question. The answer says no because it's moot. We'll be like, well, if that's true, that's the right answer. Go back to the fact pattern. If it's like before litigation, it was resolved. Well, yes, it was moot will be the right answer. I'm not saying always pick it was moot or always pick Commerce Clause, but those are answers that tend to be right if they align with answering the question and the facts presented. States do not have plenary taxing power to construct tax systems in any manner they want, right? Be wary of absolute language, like any manner they want, or they must always do this. I like may over must when I'm in doubt, some things they must do, some things they may do, but if you're on the fence, may is usually the better answer choice. An action is not ripe and therefore should be dismissed if the statute that is being challenged is proposed but not established yet. A law that punishes someone retroactively for behavior in the past is an ex post facto law, which is unconstitutional. Time, place, and manner, content neutral, will be subject to narrowly tailored to an important or substantial interest with alternative avenues of communication available. A lot of people get that wrong. Heightened intermediate scrutiny for time, place, and manner. Also going to be for commercial speech. We'll apply this heightened intermediate scrutiny standard where it's important and substantial, not compelling, but it still must be narrowly tailored and have alternative avenues of communication available. Sidewalks are considered public forums. The Commerce Clause is a solid authority for Congress to regulate the sale of prescription drugs, we said before. False or misleading commercial speech is not constitutionally protected. Nor is obscenity, defamation, words that are likely to incite imminent loss activity, or hate speech. Alienage is subject to strict scrutiny unless related to the function of the government. Population control measures targeting aliens are subject to strict scrutiny. To have standing, the case must be ripe. You cannot be considering to run for office and sue under a candidacy requirement statute. Furthermore, if you're suing for a candidacy requirement, you must sue the election official, not your party's chairman. The right to be a candidate is a fundamental right. but they would apply rational basis to aliens requirements because it's part of the governmental process. Marriage is a fundamental right that triggers strict scrutiny, contraception, marriage, procreation, education, and the right to raise your children. Privilege and Immunities Clause of Article 4 requires that states cannot impose residency requirements on non-residents without establishing a substantial interest justifying the classification. Hey, Vicky, are you here? Vicky? She asked me earlier to clarify, when is it Article 4 and when is it 14th Amendment? It's mostly going to be Article 4 when it comes to privileges and immunities. It would be 14th Amendment privileges or immunities, specifically if it was related to the right to travel. Only federal courts can issue habeas corpuses for individuals in federal custody. This is when I tell people, you let the nerds get the best of you. They like to test this. A president issues a pardon for a state crime. A state court issues a habeas corpus for a federal crime. That can't happen. They need to align federal courts for federal custody habeas corpuses, presidential pardons for federal crimes, governmental pardons for state crimes, governor pardons for state crimes, and obviously state courts will issue habeas corpuses for state custody. A ban on all forms of commercial speech, even if serving a compelling interest, likely is not narrowly tailored. For example, a statute banning all advertising of red meat in response to a proven link between red meat and cancer is overly extensive. So remember, commercial speech is subject to heightened intermediate scrutiny, but all advertising would actually be strict scrutiny because it's overly sweeping and it would be content based. If a government contractor has a bumper sticker that's political and the mayor discriminates against his company as a result, this is unconstitutional. It would only be constitutional if the speech of the government contractor's speech negatively impacted his ability to perform his job. Commercial speech is subject to intermediate scrutiny. A 30-day probationary period for mailing accident victims is usually upheld as substantially related to government interests. Fraudulent or misleading commercial speech is not protected. I feel like I'm being boring, so I'm gonna make everyone laugh here or just think, but this is a detour, not a frolic. A ban on movies showing sexual intercourse is a violation of First Amendment freedom of speech. Sex is art. So I used to have this running joke in my last administration where I'd tell people to go make art because it was sex is art, go make art. But those of you who do not know my history, I have been involved in combat sports, wrestling, boxing, and mostly those two. And back in my day, they used to say that it was good to make art before your matches, it would help you relax. But I saw some videos now where they're saying maybe it's good to retain your paint before such a match. So I don't know if it's good to make art or to hold back on making art before the exam. I'm not an art therapist, but you'll never forget that sex is art and it's not going to be considered obscenity unless it really appeals to the prurient interest of mankind and has no literary or artistic value. So hopefully that made someone laugh or something. All right. Lost profits do not constitute a taking, and you cannot recover for the price of equipment that you plan to use because it can be resold. This assumes that there's still economic viability to the land. For example, mining land is sold to a farmer and the farmer can still farm. A taxi cab driver does not have a due process right to be free from competition. Organizations and groups may deny membership rights to people if allowing that person membership would significantly impair the stated purpose of the group. Refer to the Boy Scout versus Dale case. I always call it versus Dale case, right? Like Pitbull says. So yeah, you can't, Boy Scouts are allowed to not let someone in if they're anti-Boy Scouts in general, I guess. Target discrimination against men, fathers is subject to intermediate scrutiny. They like to test that because people always know that targeted legislation against women is subject to intermediate scrutiny, but sometimes they forget that men are also a gender too. Be very hesitant to rule against a tax measure. Even if the effect of the tax only applies to one state, but the purpose is rational, then the measure is valid under Congress's plenary taxing power. So they do have broad taxing power. The state cannot put a bridge over your farm without just compensation, and allowing you to charge a fee is not equivalent, and therefore a taking has occurred. Superior officers are appointed by the president with the advice and consent of the Senate. Time, place, and manner triggers intermediate scrutiny. The takings clause is appropriate even if it's a small amount of property, like even if they take 0.001% of your oil holdings in Texas, that's still subject to just compensation. The federal government can sue the state, but the state cannot sue the federal government. Child welfare programs do not belong exclusively to the states. The federal government can regulate child welfare programs, but not workers' comp. That's usually a state issue. The First Amendment does not shield people from contract claims, right? So like if you say you're a journalist and you violated an agreement you had not to talk about something, you can't say First Amendment. They still have a valid contract claim. Strict scrutiny for alienage. It's important to note that rational basis for government functions like vote, jury duty to be a candidate. The take care clause is, that they take care and faithfully execute the law. The Appropriations Act, federal spending must be authorized by Congress. If Congress passes a law that appropriates the president to spend money on wildflowers, she must spend them on wildflowers, right? Maybe that's foreshadowing the future president. Maybe not. When I did this, actually, I can't talk about it because if I talk about it, they're not going to let me put this on YouTube. Isn't that crazy? When I did a poll about who would be the future leader of the country in which we live in and told the results, and then I tried to put it on YouTube and promote it, they said that I couldn't because it was propaganda. So no propaganda here. Vote for me in 2028. Ah, fuck, that might be propaganda. All right. Access to the ballot is strict scrutiny under First Amendment freedom of expression. There may be narrow exceptions if restriction is reasonable and non-discriminatory. Time, place, and manner is heightened intermediate scrutiny, which means important interest and narrowly tailored in a public forum. They also always ask me on YouTube if it's made for children. And I'm like, I literally fucking curse in my shit. So no, not made for children. I like the ones with Rebecca and Marion might be made for children, but my shit is PG-13, right? Under DCC, state law cannot discriminate interstate commerce or unduly burden interstate commerce. And if it does unduly burden interstate commerce, then it's subject to a balancing test of burden versus the state interest. So the dormant commerce clause is the same thing as the negative implications of the commerce clause. For those of you who just learned that right now, it's better late than never. States cannot issue federal habeas corpuses. We talked about that. You have a property interest in a state job if you must be fired for cause. For instance, if you work at the pleasure of the mayor, you do not have a property interest. A tenured professor at a public university does have a property interest. So at the pleasure of means no property interest. Everyone at IBIS Prep works at the pleasure of me, and I rarely fire people. If I fire people, you probably fucked up pretty bad because I hate firing people. I know former President Trump loved to fire people. That was his thing. Me, I don't like to fire people. I like to let people be their best. And again, that was nothing political. I don't really support any candidate. I don't really know enough about candidate Harris to speak on her, and that's that. Okay, so you cannot be fired for voting for a candidate unless it affects your ability to do your job, like the mayor, for example. Whenever I do con law, I end up talking about politics, even though I swear never to talk about politics. Commissioners are officers of the U.S. and must be appointed by the president with consent of Congress. A federal agency can have discretion on who receives a loan or funding, and that person does not have a right to a notice or hearing. Like if you applied for a loan and didn't get it, that doesn't give you a right to a notice or a hearing. A city may have time, place, and manner on strip clubs, like Ybor City. I feel like Big Rob is going to go there. No, I'm just kidding. I know Big Rob's going to be with his wife playing cards. The sale of drugs can be regulated under the Commerce Clause, not if there's a special grass growing that's so widespread. We talked about the special grass. So this is a good one, the totem pole. The top is the Constitution, then tied neck is treaty and federal law. The most recent will prevail, then state law. So federal law and treatises are the supreme law of the land. Remember, treatises and federal law also prevail over executive orders. So it would go Constitution, then neck is treatise and federal law, then executive order, then state law. So that's the totem pole. I feel like we don't see totem poles that much. When I was a kid, totem poles were really cool. I remember doing them like in art class and stuff, but like I never seen my nephew made a totem pole or anything like that. A TV station cannot claim a first and 14th offense for depriving someone of their commercial value of their work, right? So you're allowed to say like, hey, this is Andrew. I told my boot camp, I said I was the Elvis Presley of this bar prep. You gotta give me some credit, right? I'm only 34. Imagine when I'm 60. I'm the Michael Jackson of this bar prep. And if I say no one's allowed to record, you don't have a First and 14th Amendment right to record it because I have an artistic value. Now, this isn't the same art that you guys were talking about. We were talking about earlier. I mean, the artistic value of my lecture. All right. Tax will be upheld if its components are not extraneous to tax purposes and does not violate the Constitution, broad taxing powers. Federal courts have jurisdiction over cases arising under federal treatises. For example, if there's a treaty that regulates tort liability for accidents between citizens in foreign countries. That's a tough question, but it's not going to be a federal question. There is going to be federal court jurisdiction over cases arising under federal treatises. The federal government may regulate housing discrimination laws based on sexual orientation, for example, under the Commerce Clause. But if they were not allowed to do this, if Congress was regulating and saying that they were not allowed to do this on the basis of race, then that would implicate the 13th Amendment. So again, be careful. If it's on the basis of race, it's probably 13th Amendment. If it's on the basis of sexual orientation, it's probably Commerce Clause. Another thing about sexual orientation that might be tested as of recently is the idea of rational basis with bite. If you see that term, rational basis with bite, it is a real term that means like a little bit of heightened rational basis that applies to usually sexual orientation, the art of orientation, if you will. Oh, this is the last one for con law. Congress can have no role in the removal of a presidential appointee, but can have a role in the removal of lower level executives. So I think con law is interesting with what's going on in the world today, I guess. So cool. Any questions so far about those three subjects? I feel like we're moving along swimmingly.
Yeah, I had a quick question, Andrew,
Go ahead.
regarding you said something about like pilots, not pilots, but like airline companies being commercial carriers and being liable for the actions of
Yeah.
a customer, and then the next I believe point was that if someone on the plane beats somebody up, they're not liable. So what's the discrepancy or difference between
Yeah,
those
so
two?
it's about the cause of action. And when it comes to torts, be very careful. In my mind, if you have a highlighter, I don't know if you're allowed to have a highlighter, but I guess a pencil, I would circle it. Like if you guys saw my tests, when I take a test, I'm a scribbler. Like I like to cross things out, circle things, highlight things. I like to like work weirdly. And I would circle the cause of action. It would be like, do they have a cause of action for battery? So the first point said no, there's no cause of action against the airline for battery because vicarious liability doesn't really apply to battery unless it's like employer employee and battery is part of the job, like a bouncer at a club. But if it's just an airline attendant, the airline wouldn't be liable for battery. Now, the next question was saying, could they be held liable for failing to supervise the situation for, negligent supervision? Let's actually go back to that one. It was a tort one, but that was a decent, no, it's a good question. Good question. I'm not gonna say it's decent. It's a good question. So fucking weird. So it was this question, right? Sorry. Pilot. Common carriers such as airlines have an affirmative duty to protect passengers from other passengers, although it does not arise to strict liability. So that's what I'm saying. You could violate your duty to supervise. Like if you see Tommy, he's crushing what do people usually drink on planes? Ginger ale and Jack. He's crushing Jack and Gingers and he's like acting wild, and poor little Susie is sitting there like on her way to see grandma, and you don't do anything about it. And Jack like barfs all over Susie and punches her in the eye. You're not going to be liable for the battery, but you could be liable for failing, especially if little Susie was asking to be removed and you or relocated and you had knowledge of the situation. So that was a good question. Does that clarify it though? The difference between those two? The first one,
Yeah,
if we look at it, it says that there's no liability for battery. And this one says that there is a duty to protect passengers. So it would be the call of the question, what's the claim. If the claim is negligent supervision, then yes. If the claim is battery, then no. And again, every question is fact specific.
Got it. Thank you.
I got you. Let's do real property. So real property is a subject that we can overperform in. Real property and Civ Pro, people tend to do really poorly in it, which means that's an opportunity for us to do very well. So if a son lends his father money and executes a mortgage with the father on a property, and then later the father dies and the son and his two sisters take as tenants in common, only the brother holds the mortgage since it was created before the TIC came into existence. So this fact pattern is the brother lends the father money, gets a mortgage, then the father dies, then the daughters and the son all inherit. Well, that mortgage is for the benefit of the son only because it happened before they took possession. A sublease is when the tenant sublets the property for a period that's interim, not the duration. An assignment is for the duration. There's no privity between the sublessor and the landlord. There is privity between the assignee and the landlord. So sublease, if it's just for the interim period, no privity. Assignment for the duration, there is privity and all parties could be liable. The tenant, sublessor, assignor remains in privity with the landlord unless the parties constitute a novation. Ameliorative waste occurs when a tenant alters the condition of the property in a manner that increases the value of the property, but nonetheless it still constitutes waste. An acceleration clause speeds up payment, requiring all payments due, and is valid so long as it is reasonable and agreed upon. A pure notice jurisdiction protects subsequent bona fide purchasers who take for value and good faith without notice. And notice can be actual or constructive, and constructive would be record or inquiry. A buyer will be charged with inquiry notice if there's a farm on the property that someone else may have an interest in the property and therefore is not a BFP. So that'd be inquiry notice if they, should have taken note that you have a farm. The majority rule is that part performance operates as an exception to the statute of frauds for land sale contracts when 2 of the 3 conditions are met: possession, improvement, and payment. If a person conveys a life estate with the remainder man may convey that interest via will, etc. A lapse occurs when a designated beneficiary dies before the testator. Anti-lapse statutes are created to allow their heirs of a deceased beneficiary to stand in the place of the decedent. So lapse is like you bequest a piece of property to Tommy, but then Tommy's dead when before you die. So it's going to lapse unless that state has an anti-lapse statute, which would allow a beneficiary of the deceased person who is supposed to take under the will stand in the shoes. So an issue means progeny, like son, daughters, etc. Be careful to read. Issue does not mean fathers, grandfathers, uncles. It means your loins. It means the products of your art. If a party explicitly agrees not to assume a mortgage, that party cannot be held primarily liable for the payments. In real property disputes, the location of the property determines which state law to use. We call this the law of the situs. So co-tenants have a right to possession. If one tenant rents out a property through a valid will, the lease remains valid, but the other 2 tenants have a right to share possession of the property. A license is a permission to use the land of another. It's revocable and not subject to the statute of frauds. So I'm just kind of realizing something right now, which is that it's gonna take me longer than I would like to do this. And I'm looking at my calendar, so perfect. What I'm gonna do is finish real property and then finish this with Civ Pro, Evidence, and Crim Law Crim Pro Sunday at 11 o'clock. So surprise, surprise. I will do one last session. Again, it'll be recorded and we'll put it up, as soon as possible. But I can just tell because I'm getting a little bit what's it called when you're like driving down the highway? I don't know what it's called. See, I can't remember. I'm gonna just finish real property and then I'll do the other 3 subjects on Sunday. So not loopy. It's called like highway something when you're like seeing the same lights over and over. You got to pull over. But I don't think it'll be valuable for me to do highway hypnosis. Let's go with that, Rob. I like that. I'm getting a little bit of highway hypnosis. I can feel it in the crowd too, even though I don't have any way of feeling what the crowd's saying. But
I think the word you're looking for is jaded.
Yeah, a little jaded. I mean, if you all walked a mile in my shoes, then you might really know what it's. No, I'm just kidding. Okay, so let's continue real property, and then I'll do Civ Pro, Crim Law, Crim Pro, and evidence on Sunday at 11, and I think that'll be for the best. Okay, so in real property disputes, you should look for the law of the situs, where the property exists. That's probably the best place to see what will govern the case. Co-tenants have a right to possession, so people hate this question. But if one tenant rents out property through a valid lease, the lease remains valid, but the other two tenants have a right to share possession of the property. A license is a permission to use the land of another. It's revocable and not subject to the statute of frauds. So license we distinguish from an easement, because an easement is a right of use, whereas a license is a easement runs with the land, whereas a license is revocable. Let me also text my next student. You know who it is, CJ. Bella, of course I have her tonight, but let me just see if we're still on. Just give me 1 second, everyone. Hard worker of the year. We're doing the LSAT, me and her. All right, sorry about that. So under the theory of deed by estoppel, they test this a lot. A person who conveys property without authority to convey, but later receives authority, they inherit the property, for example, they will be estopped, denied from following through with the contract. The moment they receive authority via will, for example, the earlier conveyance is automatically activated. This is another one, like I've said, Commerce Clause, it's not ripe. Maybe Congress has expressly authorized this to otherwise violate the Dormant Commerce Clause. These are answers that come up a lot. And if you see the answer and it aligns with the question and aligns with the fact pattern, you can lean towards it. I think the theory of deed by estoppel, or sometimes I hear it called estoppel by deed. This is tested a lot. So if you see a situation where Tommy doesn't have the right to transfer property, but Tommy transferred it to his girlfriend, Kim, right? Tommy transfers it to Kimmy, and then that's not valid because Tommy didn't have the right to transfer it. But later, Tommy inherits the property via will. That immediately activates the earlier conveyance, and that's the theory of estoppel by deed. So from that moment that he inherited, since he had already conveyed it, it will be conveyed to Kimmy, and now Kimmy and I don't know who she's with now, Pete or Kanye. I've been doing this for so long. I used to use Kim and Kanye as my example all the time, but like they're so in the past. All right. So a sublessee is not in privity with the landlord, right? We talked about that, but an assignee would be. A purchase money mortgage is when money borrowed is used to purchase the property. Otherwise, priority is based on first in time recording. A mortgagee has the right to foreclose on the entire property, not a smaller portion. And I showed everyone this earlier, but in my courses, one of the most essential resources, and I'm going to print it out for everyone for my boot camp tomorrow, if you go to property, is the vocab list. This vocab list is like 118 words that are just like all the things that are tested. And I feel like the reason why people struggle in real property is because they struggle to know the vocab. So this is definitely something that I would encourage you all to do. It's only 10 pages. You can go through all these vocab words and it would be helpful. So a PMM, purchase money mortgage, is when the money borrowed is used to purchase a property. They'll have super priority. Otherwise, priority is based on first in time, first in recording. We have to know the notice or the recording statutes. Pure notice is going to say without notice. Race is going to say first to record. Race notice will say without notice who records first. And if it's just pure notice, the subsequent bona fide purchaser will prevail. If it's just race, whoever records first will prevail. If it's race notice, the bona fide purchaser who records first will prevail. And how do you become a bona fide purchaser? By taking for value, without notice, in good faith. For value means you paid for it. Without notice means you don't have actual inquiry or constructive notice. And then also some jurisdictions will say, in this jurisdiction, a judgment operates as a lien on property, and then it could compete with the mortgage. But usually, unless they say that, a judgment doesn't operate as a priority against a mortgage. I would have to say that in the statute. So parties may validly agree to rescind a contract for land before the closing orally, fair enough. So long as indicates a fee simple determinable. For instance, if there's an estate that is to exist so long as alcohol is not served in the property, and if the property reverts immediately, and after a tavern has been opened, there's a condemnation, the property would have reverted and the original grantor receives the proceeds of the condemnation. So the moment they started serving alcohol, it automatically reverted back. Let's distinguish between a fee simple determinable, a fee simple subject to condition subsequent, and a fee simple subject to an executory interest. A fee simple determinable will automatically revert back to the grantor. A fee simple subject to condition subsequent means if a condition occurs, then the grantor has a right of reentry. And then an executory interest is a third party interest. It could either be springing or shifting. Springing would spring from the grantor to the third party. Shifting would shift from the grantee to a third party. A non-lawyer may prepare standard mortgage loan documents, right? But they couldn't, do legal work. Sellers of residential property must disclose all the latent defects that they know about or should have known about. That's Johnson v. Davis. That's actually a Floridian case. Good old Florida. An estate that is granted to X and his heirs creates no interest in the heirs of X, and there are no restraints on alienability. X can devise as X pleases. That's the modern rule, that X and his heirs means to X, so X can devise to Y, and his heirs can't complain. Title insurance policies will protect devisees or heirs who inherit. Gabby, when I did this question earlier today, even if they are not named, because the title insurance policy is on the property, not the person. So we'll run with the heirs. An express easement is affixed to a particular spot, is not transferable to another spot. If the location of the easement is not expressed, but remains in the same place for many years, this is evidence of where the easement is to remain. If a person takes a mortgage subject to, and the agreement is they will not be liable for the mortgage, the mortgagee cannot take action against a new party because they did not expressly assume the mortgage. So let's talk about expressly assumed versus subject to. Expressly assumed means the new party is going to be personally liable, and the original party will be secondarily liable as a surety. And subject to means the new party will be secondarily liable, and the original party will be liable as a surety. There needs to be a novation for the original party to be off the hook. And if the surety pays, then the surety can seek reimbursement from the primarily liable party. So CIDs, which are like condominium interest developments or common interest developments, can enact reasonable regulations to protect common property, even if not in the original documents. However, purely aesthetic motives will not satisfy the balancing test. So it can't be like maple trees look better than oak trees, but it could be something that's reasonable to protect common property. So it is almost like a constitutional standards for common interest developments. In a race notice jurisdiction, it's the first BFP to record. A BFP takes for value without notice. The recording of the BFP in this jurisdiction will cut off any rights any non-BFPs who do not record may have had. So that's facts. The typical remedy for breach of contract in real estate is specific performance. A proper assignee can bring this cause of action as well. If two parties have a JTROS, the conveyance of either party's share will automatically turn the JTROS into a TIC. So look for that fact pattern where there's a JTROS, one party conveys, and then they convey it back to that party. Well, the first conveyance split the JTROS into a TIC, so now it'll be divisible by intestacy or will, not via inheritance. Also remember that a JTROS, right of survivorship, will prevail over a will. So if Tommy and Johnny have a JTROS, but Tommy left his, interest in the property to Kimmy in his will, Johnny will get the property over Kimmy because the right of survivorship will prevail over the will. A junior mortgagee cannot require a senior mortgagee to institute a pro rata foreclosure sale if it has a mortgage on the entire property, right? Like the junior mortgagee can't say, oh, just sell off a third and pay me the third that no. A foreclosure would be we sell the entire property to pay off the senior mortgagee, and any leftover will go to the junior mortgagee, or they'll have to seek a deficiency judgment. Remember, a statutory right of redemption would be the mortgagor's right to purchase the property before a foreclosure sale. An equitable right of redemption would be the mortgagor's right to purchase back the property after the sale. I might have said that backward. Equitable right of redemption is going to be before the sale, and statutory right is going to be after the sale. Let me say it a third time clearly because I might be getting road rage or whatever it's called. Equitable right of redemption is before the sale, and statutory right of redemption, if allowed, would be after the foreclosure sale. So typically, if a class gift is left in a will, the people from the class who are alive at the time of distribution will take. But if someone who's alive at the time the will was created but died before the distribution event, their stake will lapse as they were not part of the class for distribution. A deceased person cannot hold title to property. So if a person designated for devise is dead at the time of distribution, the gift will lapse unless there's a state anti-lapse statute. A purchase money mortgage has super priority over other creditors. A purchase money mortgage is established when the money borrowed is used to purchase the property. Under the doctrine of equitable conversion, the risk of loss passes to the buyer after the contract but before the closing during the period of escrow. The doctrine of equitable conversion also means that if two parties agree to sell a property and one party dies after the contract but before the closing, that party's estate will be forced to follow through with the deal. Most states, you do not need to be an attorney to conduct a closing, but the non-attorney may not answer legal questions. If there's a mortgage on the house, but the sale of the house will pay it off, there's no issue of marketable title because the proceeds of the closing will remove any encumbrances. So they love to test the implied warranties of marketable title. So marketable title means there's no encumbrances on the property, there's no easements on the property, no mortgages, no liens, no the property wasn't acquired by adverse possession, the property isn't subject to fee simple determinable, there's no right of first refusal, there's nothing, no threats of litigation, no weird zoning ordinances, nothing weird on the property. But if there is debt on the property, but the sale of the property will pay off that debt, then that is marketable title. So expressly assume, we said the new mortgagor is primarily personally liable and the previous mortgagor is secondarily liable as a surety. And then subject to, like we said, the new mortgagor is secondarily liable as a surety and the previous mortgagor is primarily personally liable. They test this a lot. The life estate tenant pays the taxes and interest on the mortgage and the remainder man pays the principal. How do you remember that? Because the remainder man is the one who's actually going to inherit the property and be able to sell it. They have to pay the actual principal of the mortgage. The life estate tenant has to pay the living expenses, the taxes and interest on the mortgage. Now, if the property is vacant and unlivable and no rental value, then the life estate doesn't actually have any duties because they're not going to be burdened with the life estate. There could be a life estate per autre vie, which means a life estate that's measured through another life, not the actual person living there. So an exception is when the property is vacant and unproductive, no use or income from the land, then the remainder man must pay taxes and interest because the life estate holder gets no use. A license is revocable, like a ticket to a hockey game, and it does not need to be in writing. And if a person has the oral right to cross over land but has permission, it's not adverse or prescriptive and does not do any maintenance. It's a license and not an easement. Remember, consent is like the enemy of prescription. If you are trying to have a prescriptive easement or adverse possession, it's not adverse if you have consent. If you do not expressly assume a mortgage, you're not personally liable for the mortgage payments, even if you've been making them, right? You can still seek reimbursement. Marketable title means free of encumbrances, so no easements, mortgages, no weird zoning restrictions. It wasn't acquired by adverse possession, no threats of litigation on the property, liens, use restrictions or encroachments, right? I'm like a broken record, a freaking parrot. I just said that. All land sale contracts have implied title of marketable title, though this can be expressly waived. If you deliver a quitclaim deed and agree to marketable title, there must be a marketable title. A quitclaim deed is just a deed to convey all that one owns, even if it's unmarketable, but they can still be sued for a marketable title because before the contract merges with the deed. Mortgages may dictate conditions on prepayment terms, so you can have no prepayment for 2 years, or on prepayment fees, 2% fee if paid early. If time is of the essence is not stated in the land sale contract, 2 weeks past the closing date is still a reasonable time to enforce the contract. If a will has a specific devise, like a property, and that property is sold or extinguished, it's been deemed, then the person no longer receives the property. Risk of litigation would make title unmarketable. adverse possession must be exclusive and continuous. Saffron's favorite question. Occasionally hunting wabbits while other people also hunt wabbits will not satisfy the conditions of adverse possession because it's not exclusive nor continuous. Rule against perpetuities does not apply to fully vested remainders. The rule against perpetuities will apply to contingent remainders. In the one class we did, remember, if it's to Tommy and then if Tommy gets married to Johnny, that won't trigger the rule against perpetuities because it's going to vest or not vest. It has to be like the fertile octogenarian, a sexy grandma example, where we can see if the measuring life, it's possible after their death, it's not going to vest or it will vest. We're not sure. More than 21 years could pass. So the rule against perpetuity states that no interest in land is valid unless it must. No interest in land is valid unless it must vest, if at all, within 21 years of the death of the life and being at the time the interest was created. So rule against perpetuities is just a concept. Rights of first refusals will violate the rule against perpetuities, meaning if I have a piece of land, but it says you can't sell it for 10 years, or before you sell it, Johnny has a right to buy it, right? Those would be voidable conditions under the rule against perpetuities. So if a creditor has a lien on a property and the party has a property that's partitioned via sale, the lien attaches only to that party's proceeds of the sale, not the other party, because the lien was just from the party. A deed must properly identify the grantor and grantee. So my neighbor is not sufficient if you have a lot of neighbors. But if you say my neighbor with the 3 Hondas, the horse, and the dog named Charlie, and that's only neighbor who has that, then it would probably be sufficient. If someone has a farm, you're charged with inquiry notice. We're getting repetitive. Repetition is good. A deed in lieu of foreclosure will not eliminate junior mortgages. Lean towards that answer. If you see it, it's a correct rule of law. And if it applies to the facts, it will be the answer. A deed in lieu of foreclosure means transferring a deed instead of going through a foreclosure. It's allowable so long as it's fair and reasonable, but it will not eliminate junior mortgages. Usually a foreclosure sale will eliminate junior mortgages, but a deed in lieu of foreclosure will not. CIDs may enforce reasonably related restrictions, but not purely aesthetic reasons. If there's a holdover tenant and the landlord accepts rent, a periodic tenancy will result. Notice is usually 1 full period in advance for the eviction notice. So you have a residential lease for a year, and then you hold over, you don't have a new lease, and you're paying monthly. That will probably result in a month-to-month periodic tenancy, and notice will be a full month in advance for eviction. A deed signature can be pretty much any mark, drop of blood, Prince's sign. A right to list must go through with a sale if the realtor provides a ready and willing and able buyer at the sales price. However, they like to test this if the sales price was $500,000 and they come up with a buyer for $499,000. That will not be a ready and willing buyer. Right to list versus right to sell. Right to sell means that if anyone buys it, you're going to get commission as a realtor. Right to list means that other people could list it, but if your listing sells, then you'll get the commission. So if you give someone a deed but tell them to return it if you ask for it, there's no delivery because it's not left your control. They do like to test that a lot. That delivery means that it's left their actual control. So yeah, that's perfect. We did 17 to 38, literally halftime. We're going to do civil procedure, crim law, crim pro, and I guess all subjects. We should do evidence too. Yeah, evidence. We'll do civ pro, crim pro. We'll do civil procedure. We'll do crim law, crim pro, evidence, and then we'll do the all subject review. So Ali said, "Oh, this isn't a cram guide. It's way too long." I told her that this isn't an easy test. This is the MBE exam. So I actually think that 38 pages is a solid length for a cram guide. It has 3 administrations. If you wanted to know where those cram points came from, they've come from my students, from us doing them live over the past 3 administrations and doing live questions and taking a cram guide for every single point. So I hope they're like not dumbed down per se, but written in a way that resonated and helped people absorb those points. I think that's a truly valuable exercise. I would tell people to go through those cram guides again and again before test day. That 38-page cram guide could be your savior. We will finish, like I said, those remaining subjects on Sunday at 11 a.m. If you're in my Florida course, I have a class Saturday at 11 a.m. as well. And that's it. Those are my final 2 classes for the administration. I have some sessions left with one-on-one students. Maybe you can hit up my team and try to book a session with me at the very last minute. But more likely you should look to book a session with one of my elite tutors who I believe still have some availability down the stretch. So we're here to help in any single way possible. I thank everyone for gutting it out with me tonight. I'm going to stop the recording, but I'll answer what I assume is mostly nonsense in the chat, but I will answer it. And Eduardo, I know you have your hand raised, so excited to see what you got for me. But I'm going to go ahead and stop this recording.